We will simply make some discrete points arising from Guatemala's submissions yesterday. We start by identifying aspects of those submissions that are common ground between Belize and Guatemala. The first is that it would be sensible for the court to hold the hearings on the merits in the two cases back to back, on the basis that Guatemala and Belize agree that the court should hear and resolve the merits of both disputes in a way that allows its deliberations in each of them to overlap. Belize does not object to Guatemala's application. The second point of common ground is that Honduras did not make known its claim to the Sapodillas until 1981. That was when it became aware of the Heads of Agreement, which contemplated discussions aimed at a compromise resolution of the broader dispute between the United Kingdom and Guatemala concerning the territory of Belize, and which ultimately failed. The third point is that having made a claim in 1981, Honduras then left it dormant. The fourth point is this: Honduras could have applied to intervene in Guatemala-Belize, but elected not to do so. It is undisputed, as between the three states, that there is no impediment to the complete resolution of all of Guatemala's claims against Belize. Members of the court, those are the points of common ground between Belize and Guatemala's submissions of yesterday. The next issue concerns two matters that Guatemala identified yesterday, on which it said that it would not have a chance to comment unless its intervention were permitted. The first is the Honduran claim to traditional fishing rights. Guatemala correctly observed yesterday that this claim seeks to expand the scope of the dispute submitted by Belize to the court. Today is the first opportunity that Belize has had to address the court, whether in writing or orally, since the counter-memorial of Honduras, when Honduras first raised its claim to traditional fishing rights. Belize therefore wishes now to indicate that at the main hearing it will be objecting to the jurisdiction of the court over this new claim. At the time of Belize's application, and indeed at the time of the Honduran counter-memorial, there was simply no dispute on that question. In addition, because Honduras had never before raised its traditional fishing rights claim in any forum, that claim had not been through the processes which are mandatory prerequisites to jurisdiction under the Pact of Bogotá, including negotiations. Guatemala also mentioned yesterday the rather odd Honduran argument that the Sapodilla Cayes are all rocks for the purposes of Article 121 of UNCLOS. Honduras makes no formal submission in this respect, and so no objection to jurisdiction is necessary. Belize does, however, wish to indicate that this issue is simply not part of the dispute properly before the court in the present case. Belize will elaborate on this at the merits hearing, but the dispute before the court plainly concerns only sovereignty over the Keys, not whether they constitute rocks under UNCLOS. Guatemala was explicit that this issue would arise only if the court accepted an enlargement of the dispute from sovereignty over islands to encompass what Guatemala termed maritime dimensions. But neither party has contended that the court should do so. Whether concerning the traditional fishing rights claim or the argument about classification of the Sapodillas as rocks, The more fundamental point for present purposes is this. Even if, contrary to Belize's arguments, the court were to determine Honduras's traditional fishing rights claim, or say something about whether any of the Sapodillas is a rock, by virtue of Article 59 of the court's statute, such a finding would have no binding effect on Guatemala. Members of the court, that is a point to which we will return in more general form, but we move now to points of difference between Guatemala and Belize arising from Guatemala's submissions of yesterday. Guatemala said that Belize relies on the same facts in both cases, has the same basis of claim in both cases, and presents largely the same evidence in both cases. That, members of the court, is not correct. This is, of course, not the time for any exploration of the merits of either case, but it is a time for the correct characterisation of the claims in each case. In the present case with Honduras, Belize claims sovereignty not only on the basis that the United Kingdom became sovereign before 1821, but much more importantly, because of the bilateral course of conduct since Honduras's independence. For more than a century and a half, the United Kingdom exercised sovereign authority over the Sapodilla Cayes openly, continuously, and peacefully, and Honduras not only acquiesced in the assertions of sovereignty constituted by that conduct, but positively recognised British sovereignty. The result was that the settled position between Honduras and the United Kingdom in respect of the Sapodilla Cayes was that the United Kingdom was sovereign and Honduras was not. Belize then acquired sovereignty from the United Kingdom upon becoming an independent state in 1981. Those determinative facts leading to that determinative legal conclusion do not rely in any way on the position before 1821. They involve conduct occurring as between Honduras on the one hand and the United Kingdom and Belize as its successor on the other. In the case involving Guatemala's claims against Belize, the key subject of debate is the terms and effect of the 1859 Convention between Guatemala and the United Kingdom relative to the boundary of British Honduras, and of the 1931 exchange of notes that followed it. That is a debate about treaties, and again, does not depend on the position before 1821. So whilst it is correct that some common matters do arise in the two cases, Guatemala was quite wrong to say that the issues in the two cases largely overlap. Of course, the most striking overlap is the partly similar views between Honduras and Guatemala, to which Guatemala alluded yesterday. Guatemala and Honduras agree with each other that by operation of the doctrine of uti possidetis juris, one of them succeeded to the sovereignty of the Central American Republic, which had in turn succeeded to Spanish sovereignty. They just disagree about the rather fundamental point of which one of them it was. Belize's answer is that neither of them did so, but much more importantly, that it does not matter at all because of what happened once each of them was independent. Members of the court, Belize and Guatemala also draw quite different conclusions from the decided cases on which Guatemala relied yesterday. Guatemala referred to the judgment on intervention in the Gulf of Fonseca case. In it, the court accepted that the alleged condominium regime in which the interests of 3 states were necessarily implicated was sufficient to give Nicaragua a legal interest which could be affected by the decision in that case. A condominium involving 3 states is a very particular situation. It is different from 2 bilateral sovereignty disputes, and even more different from 2 bilateral sovereignty disputes being heard in coordinated cases. Even in the case of a condominium, the court made clear that if it found that the condominium existed, that finding would have effect only for the parties to the case and would not bind Nicaragua, including by reference to Article 59. The court confirmed in its merits judgment that its findings were not res judicata for Nicaragua. Guatemala also referred yesterday to the arbitral award in Eritrea, Yemen. Contrary to what was said yesterday, that award shows that the court's determination in this case cannot prejudice Guatemala's claim to sovereignty over the Sapodilla Cayes. In that case, it was common ground that by the mid-19th century, the Ottoman Empire had acquired sovereignty over all the relevant islands in the Red Sea. Following its defeat in the First World War, in the 1923 Treaty of Lausanne, the Ottoman Empire explicitly divested itself of sovereignty over those islands. Yemen argued in the arbitration that that treaty had no legal consequences for it because it was not a party to it. The tribunal did not have any difficulty finding that because the Ottoman Empire was the relevant sovereign at the time, it had full power to relinquish sovereignty. Yemen was not in a position to dispute the validity of the Ottoman Empire having done so. And that is why, in the paragraph to which Guatemala took you to just part of, the tribunal held that this treaty created a legal reality for Yemen. In the same paragraph, the tribunal explicitly stated that if Yemen had been able to establish a superior claim to sovereignty to that of the Ottoman empires at the time of the Treaty of Lausanne, that treaty would indeed have had no legal consequence for Yemen. That case and this one are materially different. But if there were to be a parallel, it would be the opposite of the one that Guatemala suggested. It would simply be that any finding in the present case would have no legal consequence for Guatemala's claim. Guatemala used those 2 cases to seek to restrict the significance of Article 59 of the court's statute. Belize does not say that Article 59 is some sort of panacea. That was the word used in a rather confusing way by Guatemala. But Article 59 certainly does mean that what the court decides in Belize, Honduras will not bind Guatemala. And that will be so irrespective of whether the court permits Guatemala to intervene. The jurisprudence of the court is unequivocal about that, and Belize's formal submissions are framed to reflect that position. Members of the court, the dual premises of Guatemala's application are that it seeks to first inform the court of its interest, and second, to protect that interest. Under Article 62, Guatemala must establish to the court's satisfaction that Guatemala's interest may be affected by the decision in this case. Guatemala rightly emphasised yesterday that this is an objective test. That means that it is not enough that Guatemala might feel like there is a party going on to which it is not invited. Based on what we heard from Guatemala yesterday, when the court comes to examine the matter objectively, the court might genuinely wonder precisely what information Guatemala would be providing to the court in this case, which it will not already be providing to the court in the other case. And the court might genuinely wonder precisely how an intervention by Guatemala in this case would, in concrete terms, protect Guatemala's interest in addition to the combined effect of Article 59 of the statute, to the formulation of Belize's submissions, and to Guatemala's full participation in parallel as a party in Guatemala-Belize. Whatever view the court ultimately forms about the application of Article 62 of its statute to this particular situation, what matters much more is sensible coordination of the two cases. Members of the court, Guatemala made a number of surprising allegations against Belize yesterday regarding Belize's commencement and conduct of the present case. It is difficult to imagine that the court would be assisted by Belize responding to each of those allegations, so I will respond only to three that are relevant in the present context. The first is Guatemala's puzzling allegation that there was something improper about Belize commencing this case with Honduras. This was said by Guatemala to involve manoeuvres, a backdoor, and the pursuit of prejudging. Belize's straightforward and legitimate motivation for commencing the present case was to achieve the complete resolution of all claims against its territory. Belize does not seek prejudgment of any claims against it by either state. To the contrary, Belize actively seeks coordination of the court's consideration of the evidence and arguments in each case. Since Guatemala quite sensibly agrees with such coordination, it is difficult to understand how Guatemala simultaneously alleges that Belize is seeking prejudgment of anything or is seeking to walk through any back door. The second is Guatemala's allegation that Belize is, in its case with Honduras, providing only selective evidence. The only examples cited for this were 4 notes verbal concerning which it was said that Guatemala's responses were not provided. These are notes from 1985, 1999, 2013, and 2018, well after either dispute had crystallised. They were submitted in the present case for the limited purpose of showing that after Belize's independence, Belize continued to act as sovereign, while Honduras did not. Guatemala's response to those notes, if it made any, is not relevant to an analysis of the conduct of Belize and Honduras, which is what is before the court in this case. if that is what gives rise to the strongest allegation that Guatemala is able to make, the court might again wonder what the complete context that Guatemala promises to provide is going to consist of, which the court is not already aware of, and that matters for the resolution of any question before the court. All three states already have access to the full record in each of the two cases and can make submissions accordingly. The third allegation was that Belize's decision to commence the present case somehow impairs the equality of the parties in Guatemala, Belize. All we will say in addition arising from that is that if the court does grant the application, Belize respectfully requests the court to ensure that any participation by Guatemala in this case is not simply an additional opportunity to make submissions principally relevant to Guatemala, Belize. As the court knows from the written submissions in each case, Belize's case against Honduras is materially different from Belize's case against Guatemala for the reasons I encapsulated a moment ago. In this case, Belize will be fully engaged in arguing its case with Honduras, and those arguments will be of limited relevance to the other case with Guatemala. By contrast, Guatemala's position, so far as it is relevant to the two cases, is the same. That is the context in which Belize asks the court to be cautious to avoid creating any overall inequality by, across the two cases, effectively granting Guatemala more time to argue against Belize than Belize would have to argue against Guatemala. The solution towards which this militates is that if the court decides to permit intervention, the court should, in Belize's respectful submission, direct without further consultation short periods for written submissions and allocate only a short period of time to Guatemala at the hearing. President and members of the court, those are the opening submissions of Belize. We thank you for your attention.